Hello, I'm Terry Scanga, and this is Water Talks, a podcast program sponsored by the Upper Arkansas Water Conservancy District and hosted by Heart of the Rockies Radio, Salida, Colorado. Water Talks is a program that provides a listener with a glimpse into the world of people who grapple with water issues in Colorado and the Arkansas Basin on a daily basis. Our guests are experts in various disciplines, including law, engineering, hydrology, economics, water management, and other related fields. Today we have with us Amy Ostdiek. Nice to have you here, Amy.
Thank you for having me.
You bet. Amy Ostdiek is the chief of the Interstate Water Federal and Water Information Section at the Colorado Water Conservation Board, a state agency whose mission is to develop, protect, and manage Colorado's water for present and future generations. The section Amy oversees works to protect Colorado's interests in interstate water compacts and supports the coordination with federal government and other states and tribal nations in various contexts. Much of Amy's work focuses on Colorado River matters, including supporting the state in interstate negotiations. Before joining the Colorado Water Conservation Board, Amy was an assistant attorney general with the Colorado River Subunit at the Colorado Attorney General's office. Amy is originally from rural Western Nebraska. She attended the University of Nebraska-Lincoln and the University of Colorado Law School. So, Amy, part of this Water Talks is about the people themselves, where they grew up and so forth. So I'd like to ask you about growing up in Nebraska and your education and early career, and how did you get involved in water?
Yeah. Well, first, like I said, thank you so much for having me. It's great to be on the podcast with you and really appreciate you thinking of me. So I grew up in rural Western Nebraska. I grew up in a town called Scottsbluff in the Panhandle of Nebraska. And I, um, y- grew up in a family where my parents were both in public service positions. Um, my mom's side of the family, they have a cattle ranch out in Broadwater, Nebraska, not too far from where I grew up. And I spent a lot of time out there as a young kid. And, it seemed as though all of our dinner time conversations frequently turned to water. So pretty early on, I had a clear understanding of the importance of water to agricultural communities, to rural communities, but really to everything in life, right? So um, I came to see how critical it was to my family's survival, having a water supply, having a reliable water supply, and what happened when that didn't occur. So I certainly, had perspective on the importance of water at a young age. And like I said, my parents were both in the public sector. My mom was a school teacher, and my dad worked actually in water policy. He worked for a local natural resources district in Nebraska, which they're responsible for regulating groundwater use in Nebraska. So I also became really intellectually curious about water, just seeing the issues my dad was dealing with and talking about those things. I just found it really very fascinating. So that was kind of my life growing up. And then when it came time for college, I, of course, went to the University of Nebraska, which all good Nebraskans do. Go Big Red. um, and I actually started there as a music major. I played violin growing up. And really thought I was going to be a violinist, and that's what I was going to do with my career. Found out I really did not enjoy that, so quit music school. And around the same time, I actually started an internship with the Nebraska Department of Natural Resources. So, I was just a 20-year-old kid at that time. I was excited to have this internship. And when I started, I was filing documents for them and scanning things and all of that. But pretty quickly, I became very interested in the issues that were in those documents. So the things being discussed there, I was involved. I came to start working on public information for the Nebraska Department of Natural Resources. And at that time, a lot of the public information need was in the Republican River Basin, um, where Nebraska was getting sued by Kansas and spreading public information about what that Supreme Court litigation meant for Nebraskans, the implications and things like that. So through that, I became very fascinated with interstate water issues and interstate compacts, and the idea that there is original jurisdiction in the U.S. Supreme Court and how fascinating that was. Also at that time, I was starting to see that I was really interested in law. I was really interested in rhetoric, philosophy, theory type things. And it all just kind of came together. And suddenly I realized, I really want to work in interstate water issues. So it kind of started when I was in my early 20s. Um, I will say I didn't know for sure how that would all go for me. Didn't know for sure that I'd end up getting to work in interstate water issues, but I knew I wanted to go to law school. I knew that that's kind of the way that my brain worked and the way that I enjoyed thinking. So I figured that hopefully I would find my path in interstate water, but one way or another, I thought I would really enjoy being an attorney.
That's good. It's kind of interesting. Like I chuckled when you talking about water around the dinner table, because that's exactly what I kind of grew up around. The same type of thing here in Colorado, and it was always about hope we have enough water this year. It always seems to be the story. Yeah, and my dad was the president of a ditch company here in Chaffee County, and I grew up out in the field irrigating. Back then it was all with a canvas and flood irrigation. Now we do sprinklers, but that's interesting. And my brother actually attended law school at Lincoln too. I don't know if you know David or not, but yeah, he's part of Hoskin and Farina, out of Grand Junction. So anyway, um, interesting corollaries. Uh, so so I know that you're involved um, with the Colorado River issues, and I know those are kind of like the top stuff that you've been doing. Um, and the Arkansas Basin is really dependent upon a high percentage, at least 15, maybe 20% of its water supply comes from the Frying Pan Arkansas Project, which is water from the western slope from the Colorado River drainages. Um, so it's important to the Arkansas Basin, this Colorado River Compact that we're involved in. Could you kind of, for the listeners, um, kind of a high view of, you know, why is that Colorado River so important to the folks like in the Arkansas Basin? What's the nexus for that and so forth?
Yeah, sure. So, the Colorado River is critically important to the entire state of Colorado. I think that frequently you think about the Colorado River as being obviously very important to the West Slope, but in reality, the Colorado River provides water, of course, to the Front Range as well, and ultimately provides roughly 40% of our state's water supply, depending upon the year. So it really touches all corners of the state, and our rights and our ability to continue using Colorado River into the future is important to everyone across the state.
Um, I know over the years watched the Colorado River hydrology decline. I think everybody's pretty much aware of that. And we live by that hydrology, no doubt about it. If there's less water in the Colorado, we have less Trans Mountain diversions, like Twin Lakes Reservoir and Canal Company. When there's less moisture on the western slope, we have less water and so forth in our Twin Lakes through our Twin Lakes Canal, and the same thing with the Frying Pan here in the Arkansas. Um, so what have you been working on with the Colorado Water Conservation Board to try to um, I don't want to use the word level out, but it's the only one I can think of right now. Just kind of level out that hydrology to make sure that we have a reliable supply.
Yeah, that's a great question, and it's difficult to level out hydrology, right? No matter how much we would like to try to do that, it's challenging. But um, maybe it's a good time to talk a little bit about just the management legal structure around the Colorado River and how that impacts the ability we have to manage our water supply. Um, I'm glad that you started by mentioning the compact, the 1922 Colorado River Compact, which is still very much in place today. It's still enforceable. All the laws that came after it are subject to it. And that is what gave us a roughly equal apportionment to the Colorado River as our lower basin partner. So Colorado, New Mexico, Utah, and Wyoming were the upper basin states. We get 7.5 million acre feet a year. In the lower basin, California, Nevada, Arizona, they get 8.5 million acre feet a year. So those are the apportionments in the compact, and that still remains. And if you read the very first words of the compact, it's about the equitable division of the waters of the Colorado River. So that remains really important. And when we're thinking about how the supply is shared, that is a foundational principle that we keep in mind. That being said, the use of the Colorado River has been far from equal. In the upper basin, we use around 3.5 to 4.5 million acre feet a year among those 4 upper division states. In the lower basin, they use closer to 11 million acre feet a year. And this is, the reason for that really highlights the differences in how we use water and how we manage the supply that we do have. So the lower basin relies on storage out of Lake Mead and Lake Powell for their uses. But in the upper basin, we're completely dependent on snowpack. We have small reservoirs. We have relatively small compared to the lower basin. So we are stuck with what is available in a given year as regulated strictly by the state engineer based on available supplies. So what that means is that our water users have to adapt. And in years like this, that is really, really challenging. We're seeing in the Colorado Basin water rights holders who have water rights dating back to the 1800s getting shut off. So I would love to say that there's some way to smooth that out, to smooth out the supply. And there are some things we can do. But at the end of the day, we are stuck with hydrology, and we are stuck with, for better or worse, the prior appropriation doctrine that helps the state engineer determine how to allocate that limited supply. And that's just very, very different than how things have been managed and used in the lower basin, where, again, they've had this reliability, the certainty in water deliveries from Lake Mead. And that's the benefit of having the nation's largest reservoir right above your uses. We just don't have that. So, but in terms of, going forward, what we have been really focused on at the state is figuring out how to align the releases from Lake Powell and Lake Mead with available supply. We know that when Lake Powell gets low, people come looking for more water from us. So one way that we can provide greater certainty for our water users in the Colorado River is to ensure that the operations at Lake Powell are not just, have us teetering on the brink of crisis every other year. Because the less likely, the less likely that crisis is, the less likely that people are going to come upstream looking for water from us, for more water to protect Lake Powell or to send downstream. So what we've really been focused on is moving towards a more supply-driven approach for operations at Lake Powell. Largely, those operations have been driven by high downstream demand. So if we can shift to something that is more supply-driven, we think that gives the entire Colorado River Basin, including Colorado, a better chance at sustainability into the future and a better chance at certainty for our water users and also the water users downstream.
Okay. So how are we doing on that? Are we getting any traction with the bureau? Are we on the management of the lakes, Powell and so forth? Or where's the rulemaking going right now?
We're in a challenging spot, I'll be honest. So just to put this in context, this is a NEPA process, National Environmental Policy Act. So the federal government is really running the show. And they have certain things they need to do to complete that environmental analysis, the NEPA analysis. And they're working through that. So the current operational guidelines, called the '07 guidelines, expired at the end of last year. They're operational through September of this year. So ultimately, we need to know what's going to happen. We need a plan for what comes next, because that's what's going to take effect starting October of this year. So again, if the basin states don't come to an agreement, the Bureau of Reclamation is ultimately going to have to choose a preferred alternative. But the ideal course would be for the 7 basin states to come to a consensus about how the reservoirs should be managed post-2026. we haven't done that so far. We had a couple deadlines that the federal government set. Most recently, it was February 14th, and there was not a basin states consensus by that time. We're still talking, we're still working together, we're still hoping that we can figure that out. But we haven't been able to get there yet. And, one of the sticking points has continued to be the um, idea from some downstream states that they would just love to have a certain amount of water being released from Lake Powell every single year. And going back to the variability of hydrology, we know that that's not our reality in the upper basin. We moderate our uses depending on what the river is doing. We know that that's going to have to happen in the lower basin as well, and that although we would all love that level of certainty, it's just not possible in these conditions. So, again, a lot of the sticking points have been around um, managing that uncertainty in the future and our different perspectives on dealing with that type of risk.
So you mentioned the preferred alternatives. Could you kind of explicate that just a little bit, explain what those are?
Yeah, absolutely. So, when the federal government is undertaking a major action like this, they have to go through the NEPA process. They have to do an environmental review. Essentially, what it means is they have to consider the impacts of all the potential courses of action they could take, and they need to analyze a reasonable range of options that they could deploy in making this federal decision. So, the way that's playing out in the post 2026 operations of Powell and Meade, they have put out a few different options. Um, Going back a couple years now, I think the Bureau of Reclamation actually put out an alternatives report. Most recently, they put out a draft environmental impact statement, which is essentially a draft document saying, here are the options that we're looking at. The next step would be for them to choose a preferred alternative and put it in a record of decision. So, what we're seeing now is not that they haven't identified a preferred alternative. They haven't said what they're going to do yet. But what we do see is 5 different options in that draft EIS that they're considering. So, a couple things you always see in a draft EIS, the no action alternative. What would happen if no uh, action were taken? And in this case, it's important to remember that the '07 guidelines that currently govern Powell and Meade expire by their own terms. So this is kind of unique in that it's not just going to be a continuation of what we've seen in the past. Something will have to change. So in the draft EIS, you have that no action alternative. You also have a federal authorities alternative, or a basic coordination alternative, I think is what they're calling it now, which outlines what the federal government believes they have the authorities to do today if no new agreements are reached. That essentially is an outline of their perspective on what they could do without a consensus, what they could do without additional federal authorization legislation. Um, and then the other 3 alternatives are alternatives that would require additional agreements among the basin states, and they might require additional authorities or federal legislation to actually implement them. So high level, that's kind of what you see in the draft EIS. And again, I think the federal government would love for the basin states to come to them and say, we have a consensus. You can put this in your final documents, your final EIS and record of decision as the preferred alternative. We can move forward with this. We don't have that yet. So we don't know yet what the federal government will do or select as a preferred alternative in the absence of that.
Can I ask you what the sticking point is between the lower and the upper?
There are a few of them, I'll be honest. Like I said, I think one of the big sticking points is that the lower basin states have become reliant on a certain amount of water being released from the dams. So, over the course of the last 25 years, over the course of the '07 guidelines, what we have seen is releases from Lake Powell that have not been aligned with actual reality. So, going into the early 2000s, Powell and Meade were something like 86% full. And flash forward to today, again, we've seen 25 years of drought in the Colorado River Basin. But over those 25 years, the releases have been very high out of Lake Powell, unsustainably high. So the reservoirs have been drained, but the lower basin states, in some cases, still want that same amount of water that they've been getting for the last 25 years. The storage just isn't there anymore. So I think one of the major sticking points is reckoning with that fact. And the other thing is, there's no amount of we in the Upper Basin want to bring every single tool that we have available to the table, and we've done that. There are things that we can do. We can provide releases from certain upstream reservoirs, the upstream initial units, Blue Mesa, the Aspinall unit, Navajo Reservoir, and Flaming Gorge. We've put that on the table. We can also do our best to conserve water as we can. And we put on the table a pretty robust contribution program, essentially saying we are going to stand up a durable conservation program, and our water users will voluntarily conserve water when they're able to. The problem is, and the sticking point has been, we cannot provide certainty about how much water we're going to be able to conserve in a given year because we don't know if our own water users are going to get that water. So asking a water user to commit to conserving water that they don't even know if they're going to get, that's a really tough place for us to be in. Again, our lower basin partners would love certainty. They would love to know exactly how much water we would be able to provide, but the reality of living within the means of the river every year for us means that we can't provide certainty to others that we don't have ourselves. So I think those are kind of the major points. But regardless of what happens, of whether we come to an agreement or not, Mother Nature is going to do what Mother Nature is going to do, and we're all going to have to figure out how to deal with that.
Well, I was going to say something like that. Well, isn't the prior appropriation doctrine a conservation doctrine in and of itself? And I don't know about all the rest of the states. I don't know their water schemes, but I know basically the upper basin states run on some type of prior appropriation system. If the water's there and you're a senior enough, you're able to get that water. If it's not there, even if you are in priority, you still can't get all of it. So it's kind of, we're living by the hydrology. It's kind of interesting that the lower basin states, I think what I'm hearing from you, let me know if this is correct, is that the lower basin states have become so reliant upon having those big reservoirs above them that they could draw on all the time. Basically, it sounds like they've been getting all this excess water from all the past years because they have storage vessels, and they've relied on those. I'm not going to say 100%, but for a huge percentage of their water supply. Is that correct?
Yes, I think you framed the problem very, very well. And I really like what you said at the beginning, that prior appropriation doctrine is a method of conservation in and of itself. It's a way of distributing a scarce resource, and it's harsh. It is, really hard to see water rights holders, with 1860s priority states getting shut off. No one likes that, right? But that has provided a way for our water users to see with some certainty what's going to happen in a given year and how we're going to adapt to what is actually available. So that is how we do things in Colorado. That's how all the other upper basin states regulate their water supplies as well. It's slightly different in each state, but that's how it works in the upper basin. And this is also a good time to mention the legal framework in the upper basin is really different from that in the lower basin, and this kind of highlights that. In the upper basin, first of all, we're governed by a compact, the 1948 Upper Colorado River Compact. That sets up the Upper Colorado River Commission. It also apportions the 7.5 million acre feet that we received in the 1922 Colorado River Compact. But importantly, it also leaves in place the ability for each state to regulate its own water uses. So each state engineer in each of those upper division states is out regulating water use every single year. And just as we discussed, they are strictly regulating based on available supply. We've been self-regulating for decades. We have been managing well within and under millions of acre feet under our apportionment. In fact, in Colorado alone, we send over 8 million acre feet of water on average out of state from the Colorado River and its tributaries every year. And again, that's because we have self-regulated. In the lower basin, it's really different. The legal framework is different in that you have the Secretary of Interior that is water master. So as opposed to, and there are still priority the priority is still at play in the lower basin. It's just a little bit different. You have to have a contract with the Secretary of Interior to get water out of Lake Mead. So the federal government has much more of an active role in managing uses and reductions in the lower basin. Whereas up here, we've done, in my opinion, an excellent job of self-regulating ourselves so that we are not are overstretching the available supplies.
Yeah, that's interesting. I can remember being at a conference in Sacramento at the I'm trying to remember the name of it, the Irrigation and Drainage um, Association, and they wanted me to talk about Colorado's allocation system and augmentation in particular. So, for the listeners, augmentation basically is used for primarily wells to make replacements on the river, so there's no injury. But California, in particular, the folks from California had no concept of augmentation. The engineers knew that tributary groundwater affected surface water and vice versa, that there was a connection. But yet the law and the allocation system didn't recognize it. In fact, their allocation of groundwater was in a separate department from surface water allocation systems. The administrators were separate. I mean, for me, it was an absolute revelation. I couldn't believe that your engineers knew that there's a connection, but yet the law ignored it. This is kind of what we're talking about here on the Colorado compact is liable to say eerily reminiscent of that. How do they regulate groundwater in the lower basin? Do you have any idea?
That's a good question. And I should start by saying I think in an ideal world, as states, we should respect each other's sovereignty and ability to regulate our supplies within our own borders. We all do it differently. And at the end of the day, there's a reason that we all do it differently. We've developed differently. And so in an ideal situation, we should all trust each other to manage our supplies. And that is the kind of underlying theme. But at the same time, we are bound together by this 1922 compact. So we start to care about it. We start to care about how other states are regulating their water supplies when their overuse has driven the entire system into crisis and led to looks upstream to solve the problem. So I just want to preface all of this by saying that in the ideal world, we wouldn't care how it's understandable that California and Arizona would have different ways of regulating water that we don't need to get into as long as they're not causing a problem for us. So that has been the foundational principle. But again, as I said, it has become a problem for us because there have been looks upstream to solve problems that were created downstream. And the thing that I will highlight in the lower basin is, Arizona is an interesting case study in groundwater and groundwater regulation. One thing that Arizona has done to bring it back to kind of the big picture Colorado River issues and how it's impacted all of us is that they have taken, I'm going to get the number wrong, but it's something to the tune of 13 million acre feet out of Lake Mead and pumped it into the ground over the course of the '07 guidelines. That's water that, we don't fully understand how they would get it out or what their plans are to get it out. That is, the largest reservoir right now of Colorado River water that exists, given how low Lake Powell and Lake Mead are. So we would really like to better understand why they took that water out, put it in the ground with no clear plan to get it out. This also plays into broader, I think, groundwater management issues in Arizona that are all very, very complicated. But again, this is how one state's decision can impact all of us, because when Lake Mead continued to decline because of higher uses downstream, because Arizona's taking water out and putting it in the ground, because of how the '07 guidelines have worked, that's going to pull a higher release out of Lake Powell because the operations are coordinated. So the lower Lake Mead got, the more Lake Powell is going to release. So these are examples of how other states' decisions and regulations can have an impact on the rest of us. So I know that wasn't probably what you were asking. I don't know that I
No, no,
can give
no.
a
That's good. No, that was good. That was good.
good.
No, you did good on that. Uh, so to move away from the Colorado a bit, do you do anything in the Arkansas? Are you involved in anything there?
A little bit. And my team works with the ARCA committee. And yeah, I think what we are finding is that scarcity is really starting to impact all of our basins and create new issues in all of our basins. So I have certainly gotten, and my team has gotten more involved across the state than we had previously been, and also in the South Platte Basin as things have gotten a little interesting for us there too.
Yeah, I was going to ask you about the South Platte. I know on the Arkansas, anyway, this year we're looking at this. This is the worst I've seen since maybe 2002. I don't know. Trying to remember. 77 was a really bad year here. This looks like 77 a lot. I think the temperatures are warmer though. It seems to be a lot warmer than this for this time of year. But I've seen this happen before and wake up to 6 inches of snow, and I'm hoping that happens. I don't know. We'll see what happens. But yeah, talk about the South Platte. I know there's some issues going on there. I'm not real familiar with them. Could you kind of give us a high view?
Yeah, absolutely. So I will just preface this by saying I'm not going to talk a whole lot about the South Platte because we are in the U.S. Supreme Court right now with Nebraska, which, as a native Nebraskan, is an interesting, interesting situation for me. Um, but I can give just kind of an overview of where things stand. So, um, Nebraska, essentially went to the Supreme Court and asked the Supreme Court to take two claims that they are asserting. One has to do with irrigation season flows. The other has to do with a canal that is outlined in the South Platte Compact, the 1923 South Platte Compact. The compact essentially gives Nebraska a right to build a canal in Colorado that would divert water in the winter time. And it provides very specific parameters for how and where and when they can do that. And Nebraska again has asked the Supreme Court to hear two different claims, one relating to that wintertime canal, the other related to irrigation season flows. Um, the important thing to know about this is that the Supreme Court doesn't have to take the case. So it's a high bar for the Supreme Court to choose to take a case. And what we have argued, what the state of Colorado has argued in that lawsuit is essentially you really shouldn't take this case right now, Supreme Court. Nebraska has not alleged injury or claims that are ripe or ready to be heard. They have misinterpreted the compact. Um, so we are arguing that the court shouldn't even hear the case. I don't want to get into all of our legal positions there, but what I will say is that, we should know more information in the coming months about whether the court even is going to decide to move forward with it. If they do, it's going to be a long process ahead. Supreme Court litigation like this can take decades. So it's going to be a long road ahead to see how that all plays out if the court does decide to take the case. But we have made the argument that the court shouldn't even consider it right now.
Okay, that's good. Uh, I don't know much about it, so I would be very ignorant. My questions would be, I have no idea what to even ask you on that one.
Well,
Uh,
I maybe one thing I should say that I didn't mention is one of the key points is just in the irrigation season flows. The way the compact works is that it's administered to a certain priority date. If the flow of the river is below a certain level, it's administered to that date, and that's one of the key disputes. Is um, you know a plain reading of the compact says the river should be administered to that priority date. It's not a firm delivery obligation of that member. So that's kind of what the summertime flow issue is about.
okay. Now that you mentioned that, just going back to the Colorado a bit, I think one of the misconceptions that a lot of folks have is that there is um, some number that Colorado has to deliver to the lower basin states, or Colorado, the upper basin states have to deliver. But that's not really true. I think you talked about this a little bit, but could you just talk a little more about that? Because I know a lot of folks in Colorado who are involved in water who make comments about this obligation and not fully understanding it.
Yeah.
Eh, Could you talk about that?
Yeah, absolutely. I'm really glad you brought that up. So, I will talk about the non-depletion obligation, but I think it's interesting to look at what everything that comes before that, that part of the compact. Again, the very first words of the compact were about the equitable division of the waters of Colorado River. You have apportionment, 7.5 million acre feet to the upper division states, 8.5 million acre feet to the lower division states. And another interesting thing to consider is what was going on leading up to the compact. You had California developing very rapidly. And meanwhile, you had a Supreme Court decree that came down that said, again, before the 1922 Colorado River Compact, this decree said if two states have a water dispute and share a river and they both recognize prior appropriation, that will apply across state lines. So Dolph Carpenter in Colorado, looking downstream, seeing California develop, was very nervous about that Supreme Court doctrine applying. But here's the thing, is that when you have a compact, the terms of that compact will govern, not the Supreme Court's jurisprudence. So the entire intent of the compact was to not have California have a senior priority. So going back to priority, it doesn't apply across state lines where there's an interstate compact that governs. So another thing you hear sometimes is California has some priority over Colorado or the Upper Basin, and that's not true. That was the very point of the compact, to put us on equal footing and, again, to give us equitable shares of the river in perpetuity forever going forward. So all of that provides the context for and comes before the non-depletion obligation that comes later in the compact that says the upper division states shall not cause the flow of the river to be depleted beyond 75 million acre feet over a 10-year period. And a couple things to note about that. It is a joint and several obligation. So it's not an obligation that Colorado has alone, but all four of the upper division states share that obligation. It is met at Lee's Ferry, Arizona, pretty far downstream from us. But it is just that. It is a non-depletion obligation. So what that means is that, if the flow of the river were to get to that point, 75 million acre feet over a 10-year period, you would really have to look at what caused that. There's a causation component here. So when the upper division states are using millions of acre feet less than our apportionment, that is going to certainly impact the causation of what's causing those flows at Lee's Ferry to decline. You might also look at how much the lower basin is using. There are a lot of things that would go into that inquiry. It's not just a straight delivery obligation of 75 million acre feet over a 10-year period. And if you look at the negotiating minutes to the compact, if you look at what Dolph Carpenter was really thinking going into that, it was that we need to figure out how to manage with really variable hydrology. And setting ourselves up for a delivery obligation would not achieve that. So that's why it's structured the way it is.
Yeah, I think the problem with the folks in Colorado is we're used to the prior appropriation doctrine, and we don't understand this equitable apportionment doctrine as much as we probably should. We should study it a little more. So you mentioned Dolph Carpenter. The listeners don't know who that is, or maybe. So could you talk just a bit about who he was? And you already mentioned one of the things he's done. But I think that'd be good for the audience if you could give me a little bit of information about that.
Yeah, absolutely. And I am not qualified to give a comprehensive overview of Dolph Carpenter and his life, but he was a really important guy to Colorado for a lot of reasons. Um, he was a water attorney in Greeley. He worked on behalf of the state in a lot of different issues. Interestingly enough, that Supreme Court decision I was just talking about, where it was determined that prior appropriation would apply across state lines, he actually argued that on behalf of the state of Colorado. But when I think about Dolph Carpenter, I think about the father of the Interstate Compact. He was really a visionary. He, based on his own experience, based on his deep understanding of how things worked in Colorado, but also across state lines, it was his idea to use the compact clause of the U.S. Constitution to develop an interstate compact, and he helped develop the very first interstate compact on the Colorado River. So when I think about Dolph Carpenter, that's really what I think about, as a visionary who saw a path forward for states to develop their own solutions to contract with each other, essentially, so that we didn't have a court coming in or the federal government coming in and telling us what to do, but rather we're managing within the tools and the legal framework that we wanted to create for ourselves.
Oh, very good. That was good. I've read some years ago, The Silver Fox of the Rockies. That book. It's very good. I should read it again because I've forgotten most of it.
I was
But that
just, yeah, when you said that, I thought I need to, because I read that book when I started at the Colorado Attorney General's office, and I didn't know anything then, and now I know a few more things at least. So I feel like I need to revisit that book and get to
yeah,
know Delph again.
I need to do that too. That was good. That was a good explanation, though. I thought you did a great job with that. Well, so just generally speaking, and then I'll let you go because I know you have other appointments. Um, how many compacts are there in Colorado that your department oversees?
Well, I want to be, so there are 9 interstate compacts, 2 U.S. Supreme Court decrees that Colorado's a party to. But our involvement in them really varies because if you look at all the different compacts, they work really differently. Some of them are strictly water rights, or not water rights, but administration, right? Some of them are more in the state engineers area where the river is just administered in a certain way. Some of them, like the South Platte, are now in active Supreme Court litigation. So our attorneys work on those. We really get to work on the policy side, negotiation side, things like that. But it highlights that, we all have to work very closely together across the AG's office with the Division of Water Resources, the state engineer's office. We all work really hard to stay coordinated and work together so that even if, as I'm supporting Commissioner Mitchell in Colorado River negotiations, so that none of that, what we're doing over there, is going to conflict or cause problems in another basin. Um, so we work very, very closely together in all of the to protect Colorado's interests in all the interstate compacts that we have.
That's very good. Well, is there anything else you'd like to discuss? Just
I
kind of
don't,
open ended. Anything on the Colorado happening that other than what we've already talked about? That's
you
probably
know,
not,
I,
huh?
I don't think so. I guess what I would say is just it'll be an interesting few months. It's really a critical time for the basin states to come to a consensus. And if we don't, then we'll see what the federal government is going to do sooner rather than later. So keep keep watching what's going on. It'll be an interesting and tough year.